Hey everyone, welcome back to today's video, where we bring you the intense and long-awaited conclusion to this unbelievable courtroom showdown featuring Judge Perkins delivering a sharp, no-nonsense reality check to a young self-proclaimed sovereign challenger who tried to outsmart the system. Part 1 was powerful and packed with tense moments, but Part 2 takes everything to a whole new level with stronger arguments, tougher questions, and dramatic twists that you definitely don't want to miss. So sit back, stay locked in, and let's jump straight into the action.
Are you, you've been here before, correct?
Yeah, I've been here before.
Have you made any kind of filings on your behalf?
Yeah, quite a few.
This is the city of Detroit versus Jamil Amir Lockhart. Appearance for the record, please.
So I am Jamil of the family Lockhart. The motions that I filed and the documents that I've filed have all been trying to ascertain the jurisdiction of this court. And I don't understand the nature and cause of the action against me. And I'm trying to understand under what jurisdiction the court intends to proceed. First of all, is this going to be a civil or a criminal action? Criminal. Okay. Your Honor, the Constitution grants this court two criminal jurisdictions. One is criminal jurisdiction under the common law, and one is a criminal jurisdiction under admiralty or military tribunal. From Article 1, Section 8, Clause 817 of the Constitution.
What kind of out-of-nowhere logic are you running on? Because Article 1, Section 8, Clause 17, also known as the Enclave Clause, clearly establishes the federal government's authority to create and control a designated federal district for the District of Columbia, and it's written in plain, undeniable constitutional language that leaves no room for confusion, misinterpretation, or made-up theories. So if we're going to argue facts, let's argue real law instead of wild assumptions.
In which of these two criminal jurisdictions does the court intend to try me?
Where is your motion, sir?
There's a motion filed there. It's a motion to dismiss based on lack of subject matter jurisdiction.
All right, I'm going to deny that motion. I'm going to set a bench trial or jury trial if you choose. Which one would you want to have?
Okay, Your Honor, under what grounds, what facts and findings, conclusions of law are you denying that motion to dismiss? I'm trying to understand the jurisdiction of the court. You have not disclosed it to me. I'm asking you
to disclose it to you. Check the court rules, sir.
Well, Your Honor, the Sixth Amendment grants me the right to understand the nature and cause of any action brought against me, and it grants you the duty to inform me. So I don't think you would be breaching your oath of office if you were to inform me under which jurisdiction this court intends to proceed. In order for me to intelligently defend myself without an attorney, I need to understand which jurisdiction the court intends to proceed to conduct
You have a very good attorney on the line, Mr. Elwood Terry. If you want to speak to him in a breakout room, I can give you that opportunity. Other than that, I'm going to set a bench trial or a jury trial in the matter.
Okay. Please let the record show that I have attempted to understand or to ask what is the jurisdiction of the court is operating under. And it appears that the court is operating under a secret jurisdiction. Maybe only known to bar members and licensed attorneys. So let the record show that I am trying to understand jurisdiction and nature of cause against me, and the court has denied me that information.
I'm not denying you the information. The information is public information, sir. The information is outlined in the Michigan court rules. You need to read the Michigan court rules, and you can find out jurisdiction. It'll tell you everything about jurisdiction. That's entirely public information. You can go online and type in the court rules. The whole book is ascertainable to you online.
Sir, the Sixth Amendment grants
I'm not
you
required
to inform me of the nature and cause of any action brought against me. And right now you're denying that right.
I'm going to continue, sir. Don't speak over me. You want me to inform you of the nature and cause of the action. You're charged with driving. Drive while license not valid or improper. The other charges, no insurance, misdemeanor. The allegation is that you were driving the same 2011 Jaguar in the city of Detroit without the proper registration on that vehicle.
Who could have guessed?
That kind of behavior in a courtroom isn't just disruptive. It can be treated as contempt. And while the Sixth Amendment absolutely guarantees your right to be informed of the nature and cause of the accusations against you, it does not provide a guarantee that you will personally understand every legal concept if you choose not to listen, learn, or engage with the process in good faith.
Interrupt me, sir.
Okay, go ahead. I'm sorry.
Those are the charges. Do you want a bench trial or a jury trial?
Your Honor, I am trying to understand the jurisdiction of this court.
And I told
As I said, you told me it was a criminal jurisdiction.
If you read the Michigan court rules, the Michigan court rules will tell you and give you jurisdiction. So they have a copy of the Michigan court rules online or at the public library. I'm sure it is easily ascertainable, and we're not going to keep going down this road, young man. Do you want a bench trial?
So I cannot. I'm asking you a very specific question, and it is this a criminal jurisdiction under common law, or is it a criminal jurisdiction under military tribunal?
Listen, let's move on to the next person.
Sir, please answer that.
It
can only be one or the other.
You'll leave me no choice but to hold you in contempt. I'm asking you a specific question.
Your Honor, I do not wish to be held in contempt. I am trying to exercise my Sixth Amendment right. I can show you Constitution. This exercise of a constitutional right cannot be converted into a crime.
There is no such thing as admiralty law being randomly applied in a standard courtroom the way some people imagine. And to be clear, it's called admiralty law, not a made-up variation. And unless you're standing on the deck of a ship in open water, that kind of jurisdiction simply doesn't apply here. So that wraps up his first court appearance, and at his second appearance, just like the first, he stayed behind until the very end of the docket, not to resolve anything, but to keep arguing with the judge instead of moving the process forward.
The court is via motion, okay? If you have a motion that I've already denied one of your motions, if you have another motion,
under what basis? Under what grounds have you denied my motions?
It's not my job to explain to you all of the court rules, sir.
Sir, there's only two jurisdictions which this court can operate under.
Just like any other, you're going to be treated just like any other lawyer that comes in this courtroom. So you have to know the rules.
Yeah, so I'm not trying to seek legal advice or ask you what the rules are. I'm asking you a very specific question. There can only be two jurisdictions under criminal law. And is it under common law or is it admiralty?
So by that kind of logic, you'd be handing out a free pass from accountability just because there isn't a direct complainant and no imaginary contract was signed. But that isn't how real law works. Because the moment you use public roadways, rely on public services, or demand that your rights be protected inside a courtroom, you're also accepting the laws and responsibilities that exist to make those rights meaningful. And you don't get to claim the benefits of the system while pretending that obligations don't exist.
Mr. Jamil Lockhart.
Yes.
All right. This is the last time I'm going to say this. I'm not going to continue to go back and forth with you regarding court rules and all of those positions that you have. If you put it in a motion, we'll set a motion hearing date.
If you are setting a motion hearing date, you are doing so without my understanding of the nature and cause of the action against me.
Listen, I
cannot move forward until I have these questions answered. These are basic questions that you are obligated under the Sixth Amendment.
I'm not obligated to answer any of that stuff. I told you, I gave you the answer to that stuff by looking in the court rules. You're obligated to know the rules.
Sir, what you mentioned is statutory law. And if we are proceeding under some kind of statutory law, I motion that we dismiss for lack of a sworn complaint or anything signed by injured party. And in fact, where is the injured party? Is the officer present, and who is the injured party in this case?
The officer is not required to be present today. It is a pretrial date. I'll hold that dismissal motion in abeyance until the date of trial. If there's no signed complaint on the date of trial, then we will dismiss by no signed complaint. So I'll give the city an opportunity to come up with a signed complaint.
I'm sorry, is the city the injured party here?
Yeah, you're here.
Okay, well, sir, I move that we either dismiss this case or move this case to federal court. If the city is the plaintiff or injured party, they cannot also be the judge and prosecutor.
File a motion on that, sir. If you're saying that I do have a signed complaint one.
Well, that brings me back to my original question. Is this a statutory proceeding? Because if there is, there would have to be an international contract or agreement. And I would implore the prosecution to put that agreement on the record and explain how I am party to it.
Young man, you gotta go do your homework, okay? And it appears that you're taking this position and you're adamant about this position, and you're free to do that. Now, whether you're gonna win at this position, that's gonna be up to what you say in your brief, and how it relates to the law, and we'll make a decision on that stuff, okay? But at this point, you need to educate yourself, because you seem like a very articulate, educated young man. You need to educate yourself on court rules and procedure. Until you get it correct, we can't talk, because we have to be speaking the same language, okay?
I mean, that's the main thing I'm trying to understand here, sir. Is this a common law criminal procedure or
I've given you some direction on.
Well, sir, I don't know which rules. If you could tell me where I could find the rules for.
I told you, go to Michigan court rules. They got Michigan court rules.
They have rules for criminal procedure under statutory law.
Yes. Very much so.
Could you please direct?
Because you refused to stay silent and focus on the court's instructions, you completely missed what was actually being explained, and instead of listening, you tried to talk over the judge and dominate the moment, when in reality the court was offering a simple path forward by skipping unnecessary formalities for future dates you clearly had no intention of honoring, and warning that failure to cooperate could result in an immediate warrant being issued.
To it. Michigan court rules. There's a book that's over 1,000 pages, and it'll answer, well, close to 1,000 pages. It has those questions outlined in there. You're expected to know
Are
that.
those Michigan court rules, is that statutory law?
I'm not gonna keep going back and forth with this stuff. Whatever motions that you have, that's how you speak to the court, through motions. And whatever motions that you have, I will review it. I read all the motions that come across. I check all the law myself. And if you have some law, I would suggest that law that you're saying that we don't.
Your Honor, there is no international contract. I mean, we've asked the prosecutor to produce an international contract that would bind me to this statutory proceeding. And I'm not aware of any contract. In the absence of such contract, I motion that we dismiss.
Let me break this down clearly, because after watching enough courtroom battles, it's obvious that what you just said is the fastest way to hand a judge the perfect opportunity to assert authority and make their point in one move, not only reinforcing their jurisdiction over you, but also setting a clear example for anyone watching exactly what behavior will not be tolerated moving forward.
For the record, I would just
in order to, you can move to the circuit court, and you can appeal my decision as it relates to that. But we're not going to keep on going back and forth.
I think we should move this case to federal court. As I stated, if the city is the inter-party,
file a motion so I can, on your removal motion, file a motion.
I do not wish to continue or delay this any further. There's been no evidence presented to substantiate any kind of jurisdiction in this case. This is our second time. I've asked for this the first time, and there's been no evidence of any jurisdiction. And I don't understand why, you're insisting on, moving to another court date, and we have not addressed this very basic and fundamental issue of jurisdiction. If it cannot be proven and proven on the record, then this case must be dismissed. I mean, I don't understand why we are delaying this any further.
We don't have to delay it any further. I can put a warrant out for your arrest, and you don't have to show up. I mean, you'll have to deal with that then. But at some point, you're gonna have to deal.
Under what grounds, under what basis are you putting a warrant out?
Being told to look at 30 days isn't the same as being sentenced to 30 days. You still have a chance to protect yourself, and the smartest move is to take the free legal counsel offered, just like anyone watching this video would do. But Lockhart refuses, thinking he's some kind of expert who knows better, when in reality, no one is above the system or the protections it provides.
And I said, if you're telling the court that you're not going to come back to any court dates, then that's up to you. All I can do,
what I'm saying, sir, is I don't wish to delay this any further. There has been no proof of jurisdiction. There is no live injured party. I mean, there's a claim that the city of Detroit is an injured party, but I'm not aware of any international agreements or contracts that I've entered into with the city of Detroit, and the prosecutor can't provide that. And it seems like there's a bias going on here, because flat on his face, the prosecutor hasn't even spoken on this issue. And you just insist that we move to another court date, and I don't understand. I mean, your oath of office is to uphold the Constitution, and what I'm asking is
what you're saying in essence is that I don't have any authority.
I'm asking you to prove.
Most people who end up in jail for contempt of court do so without realizing that the court's patience is a personal courtesy, not a legal requirement. And while consequences are perfectly enforceable, your acceptance or acknowledgement isn't what gives the court its authority. It's simply a matter of following the rules and respecting the process. High voltage.